Welcome, I'm Kirsten Howe, and tonight we're going to be talking about Medi-Cal planning. What do we mean by Medi-Cal planning? There's lots of different things that Medi-Cal covers. Medi-Cal pays for our health care for some of us. What I'm talking about tonight is the Medi-Cal that helps us pay for nursing home care when we are elderly and we can no longer afford to pay for it for ourselves. Sometimes we have a need to be eligible for Medi-Cal, but we aren't already eligible, and that is the kind of planning that I do, and I'm going to talk to you about that. One of the important things that I have to lay out from the beginning is the difference between Medi-Cal and Medicare. A lot of people get those two things confused. They happen to sound very much alike. Medicare is an entitlement program, meaning once you achieve a certain status, you are entitled to it. And that status is you are 65 years old and you have somewhere along the line somehow paid into Social Security. You are entitled to Medicare. Medicare is our health insurance when we are over the age of 65. Medi-Cal is another kind of a benefit. It is a needs-based benefit. It's not an entitlement benefit. You have to demonstrate to Medi-Cal that you need it. And by need, there's a financial component. You need it because you financially need some assistance. A big difference between Medicare and Medi-Cal, and there's a certain level of misconception out there in the world. Many people think, oh, I don't need Medi-Cal and I don't need long-term care insurance because I am covered by Medicare. If I ever needed to go into a nursing home, Medicare would cover it. Medicare does not pay for nursing home care. Medicare pays for rehabilitation. Many times when people go into the hospital, they have an incident or they have a procedure and they're not quite ready to go home. They're not well enough to go home, but the hospital can't keep them. They're not sick enough to be in the hospital. So they go to a rehabilitation facility. Those are nursing homes. You go to the rehab facility to get yourself well enough to go home. As long as you are actually rehabilitating, and by that I mean your doctor thinks you're still improving, Medicare will pay for that. If you are on Medicare, Medicare will pay for that up to 100 days. But once you stop improving, if your doctor thinks this is as good as you're going to get, Medicare stops paying. And if you need to be there because you aren't able to care for yourself, then you switch to being private pay. You're paying the nursing home to stay there. They're very expensive under those circumstances. $8,000 a month, $10,000 a month. I have a client who we recently got Medi-Cal for her and her husband. She was paying over $20,000 a month to keep her husband in a nursing home after he had a stroke. Now, Medi-Cal is going to be paying that bill for her. So those are important distinctions between Medi-Cal and Medicare. What we're going to be talking about tonight is Medi-Cal because it is a needs-based program. So what we are doing for our clients is getting them into a situation where they can demonstrate that they need Medi-Cal. So we have to talk about the eligibility rules for Medi-Cal. There are three components of Medi-Cal eligibility. The first is medical. You have to actually be in a nursing home and need to be in a nursing home. Your doctor has to be of the opinion that you cannot take care of yourself on your own such that you need to be in a nursing home. So medical need. I'm a lawyer, I'm not a doctor, I can't help you with medical need. I can help you with the other aspects of eligibility. The second one is income. Your income has to be low enough that you can't afford to pay the nursing home. So that's a pretty, in most cases, a pretty straightforward calculation. If your income is $5,000 and the nursing home costs $10,000, income-wise, you are eligible. When we're doing the planning, for the most part, we're focused on the asset part of the equation. Your assets have to be below a certain level to be eligible for Medi-Cal. So a lot of the planning that we do has to do with taking care of assets so that we are eligible. Assets eligibility is one of the key components of Medi-Cal eligibility. So now we're going to talk about what does that mean? What are the thresholds that you are not allowed to go over? So the assets, when we're doing Medi-Cal planning, the assets fall into three categories. There are exempt assets. Those are assets that don't count against you. When you're applying for Medi-Cal, you are allowed to have your exempt assets. Your exempt assets are going to be your home, currently under California law of any value. Could be a $2 million home and you still could be eligible for Medi-Cal. You are allowed to have one car of any value. The other things are a mixed bag of things. Life insurance policy, term policies you can have of any value because they don't have any value to you. They're term policies. But a permanent life insurance policy, you can have that. You can have the belongings in your home, you know, your couches and your TV sets, whatever you have in your home. That's generally permitted. You are allowed to have $2,000 in other miscellaneous stuff. And if you're married, your spouse can have their IRAs and 401ks, and your spouse is allowed to have $123,600. That's the 2018 number, and that number changes every year. $123,600. So a married couple can have, again, house, car, that little life insurance policy, the contents of the home, $2,000 plus $123,600. That's what you're allowed to have and be eligible for Medi-Cal. And that number, the $2,000 and the $123,600, that can be anything. That's the value of it. It doesn't have to be dollars. It could be securities worth $123,600. It could be another piece of real estate that's worth $123,600, although I don't know really where you would buy that in California, but it could be. It could be anything, but it has to be less than those numbers. So those are the exempt assets. We also have what we call unavailable assets, which makes them basically exempt. They're not exempt assets, but because they are considered unavailable, we can have them. So examples of that are the IRAs and the 401ks of the applicant, the person who's applying for Medi-Cal. They can have their assets as long as their 401ks and their IRAs, as long as they are on a what we call a payout structure. So those of you who are over the age of 70 and a half, you know this. When you reach 70 and a half, you have to start taking required minimum distributions out of your retirement assets. You know that. I hope you know that. If you don't know that, I'm telling you now, and you better run down and do it. The same thing is true if you apply for Medi-Cal and you have IRAs or 401ks. You have to start taking required minimum distributions. If you do, then you can keep that asset. You can keep that IRA or that 401k. Those required minimum distributions, however, are counted as income. And that's going to become an important point in a few slides. We'll get to that. But the asset itself doesn't count. It's considered unavailable, and therefore it's treated like it's an exempt asset. Certain kinds of annuities are also considered unavailable assets. This is not going to be a course on annuities. That's a very long, detailed conversation. Every annuity contract is different. All you need to remember is that, oh, that's an issue, an annuity. That's an important thing. We have to figure out, am I allowed to have this annuity, or do I have to do something else with this annuity? Remember, an annuity can count as part of your $2,000 or part of your $123,000. So we have options, and there are things we can do. But just bear in mind, annuities can be exempt or unavailable and therefore treated like exempt. Everything that I haven't mentioned so far is considered non-exempt, and therefore it counts against you. If you are applying for Medi-Cal and you have too much, you will not be eligible. Okay? Now we're going to talk about some of the issues, some of the points, some of the rules that we have to keep in mind when we're doing this planning. And I'm going to talk about each one of these things in more detail in just a minute. Right now I'm just telling you, share of costs is an important concept in Medi-Cal planning. The look-back period is an important concept in Medi-Cal planning. The penalty period is an important concept. And estate recovery is often an important concept. And we're going to talk about each one of these in a little more detail. Share of costs simply means the amount of money that you have to pay for your nursing home care. So you have become eligible for Medi-Cal. Medi-Cal is going to pay part of the cost of the nursing home, and you are going to pay part of the cost, and that's called your share of costs. So how that is calculated is all of your income, you're in the nursing home, all of your income from all sources goes to pay your nursing home bill, except that you get to keep $35 a month. So you can buy yourself some toothpaste and a candy bar, you can treat yourself to Starbucks 3 or 4 times, I guess. You get to keep $35, everything else goes to pay for your nursing home care, and Medi-Cal pays the rest. That's your share of cost, is that amount that you are required to pay. So if you're on Social Security, that goes to nursing home care. If you have a pension coming in, that goes to nursing home care. If you have IRAs and 401ks that you're pulling distributions, required minimum distributions, remember a couple of slides back I said that's going to become important. If you're taking those required minimum distributions, that's part of your income, and that has to go toward your share of costs. If you're married, it's a little bit different. If you're married, your spouse at home is entitled to what we call a minimum monthly maintenance needs allowance. It's a big mouthful, but your spouse at home is entitled to, if there's income to support it, a certain amount of income. Right now that amount is $3,090. That's the 2018 number. So what that means is if your spouse has Social Security, your spouse at home has Social Security, $1,000 a month. That's not enough. Medi-Cal would like for your spouse at home to have this amount, the $3,090. Okay, but she only has $1,000, and you have $4,000 a month of income. What that means is the $2,090 difference. Your spouse has $1,000, Medi-Cal wants her to have $3,090. The difference is going to come from your income. So instead of 100% of your income going to the nursing home, some of it your spouse will get to keep, because our spouse needs to have enough money to live off of. Some of it spouse gets to keep. You get to keep your big $35 allowance every month, $35, and the rest goes to the nursing home, and Medi-Cal will pay the rest. Okay? That, I know that's very confusing, but if there's enough income, the spouse is entitled to keep that much. Sometimes we don't have enough income to push $3,090 to the spouse, but if we do, we are allowed to do that. So that's how we figure out your share of costs. So look back period, when we submit the Medi-Cal application, we have to disclose to Medi-Cal all the gifts that we have made to people during the look-back period. So the look-back period is 2.5 years unless you have a trust and you've made transfers to a trust. And most people in California who do estate planning of any sort have a trust. If you made any transfers into a trust, if you've made any gifts to your children, grandchildren, you have to disclose that on your Medi-Cal application. If these gifts were made in the last 2.5 or 5 years in the case of a trust. You just have to disclose it, and that time period, that 2.5 years or 5 years, that's what we call the look-back period. It's not anything to get excited about because we know it. We know we have to disclose it, and so when we're doing the planning, we keep that in mind. The look-back period is calculated from the date you submit your application for Medi-Cal backwards. It doesn't matter when you went into the nursing home, when you first became disabled. It's when you submit the application, we look backwards 2.5 years or 5 years. The most significant, perhaps, is what's called the penalty period. What that means is when you submit your application for Medi-Cal, you're going to submit it when you know you're eligible. You know you medically need to be in a nursing home, and you are in a nursing home. Your income is low enough and your assets are low enough. So you submit the application when you know you are eligible, and Medi-Cal reads your application and they say, yep, you're eligible. But we are going to make you wait for a penalty period. And the penalty period has to do with the gifts that you've made. Remember on the last slide I told you, we have to disclose all the gifts that we've made. We have to disclose all the transfers that we've done in the last 5 years. We put that right on the application, and Medi-Cal reads the application and says, yes, I can see that you're eligible, but because of these gifts you made, you're going to have to serve a penalty period. There's going to be a time when, even though you're eligible, we're not going to give you any benefit. You're going to have to wait. So that penalty period is calculated based on the value of the gifts that you made. It's a little complicated, so bear with me. There is a average private pay rate, is another acronym, APPR. I'm sorry about all the acronyms. What that is a number. It's a dollar amount. It's $8,841 this year. That number is used as a divisor. And so just listen for a little bit and you'll get what I'm saying. Divisor is a word we probably haven't heard since about 4th or 5th grade when we first learned long division. So let's say you make a gift of $40,000. You just write a check to your grandchild, $40,000. Here you go. Buy yourself one of those new Teslas. Let's just pretend the number that I gave you is $8,000, because 8,841 is, that's too difficult, the math. If that number was $8,000, we would take that $40,000 gift, divide it by 8,000, and what's the answer? 5. Oh, we have a CPA in the room. The answer is 5. So what that means is you would be, if you made that $40,000 gift, you would have a penalty period of 5 months. So even though you are eligible for Medi-Cal, Medi-Cal is going to say, nope, for 5 months you don't get it. Now, we know that, so we can plan around that. What can we plan? We can plan the size of the gift. If we don't want to be ineligible for 5 months, then let's make a smaller gift. Let's make a $20,000 gift, and then we'll only be ineligible for 2.5 months, and Medi-Cal rounds down. So we can play with the size of the gift. We can play with the number of the gifts. Every gift you make has its own penalty period, and they all run at the same time. So if you made 5 gifts of $8,000 or 1 gift of $40,000, which one of those would be better? You're going to get 5 one-month penalties that are all running at the same time, 1 month of ineligibility versus 5 months of ineligibility. So that's where the planning comes in, is kind of working with that penalty period. The good news also is that the penalty period starts running the day you make the gift. So you might have made these gifts 3 years ago, and now you are in a nursing home because you need to be medically, you have low income and you have low assets, you're submitting your application, you've already served your penalty period. You served it 3 years ago when you made the gift. So we call that advanced planning, when we make these transfers way in advance so that the penalty period is over before we ever need Medi-Cal. We call the other kind of planning where we come into my office and we need to get eligible right now because somebody's already in a nursing home. We call that crisis planning. So which of those would you imagine is more difficult and therefore more expensive? Crisis planning. Very good. Very good. But it can be done. It can be done because now you see We manage the penalty period by managing the size of the gift. We have to disclose it, and that's okay. That's a legitimate application. We don't mind that, but we do the planning and we figure out how much penalty period can we afford to serve. And we do the planning accordingly. I'm going to give you just a little bit of a comparison of our current California law and the law that is kind of lurking out there, the law that will be our law if the legislature ever gets around to actually activating it. It's been written, it's on the books, it's just not yet effective. And I've been talking about this, I don't know, maybe since 2011, 2012, and we keep saying it's going to be passed any day now, any time, we just don't know. When the new law passes, it will be much less generous than what we have right now in a few different ways. But the big one is that the penalty period will start running on the day you submit your application, not on the day you made the gift. So doing a lot of advanced planning, it's good. It's always better and easier on everybody, much less stressful to do advanced planning, but that penalty period isn't going to be over with. So that's one thing. And the other thing, when the new law passes, those penalties that I talked to you about, they're not going to run concurrently anymore. They're going to be stacked up end to end. So it'll be a lot harder. Right now, under current California law, we can protect pretty much anything if we have enough time and we have the will and the desire to do that. My friends, my colleagues who work in other jurisdictions who have the new law, California actually is the only state left that doesn't have the new law. My friends who do this same work in other states, typically in crisis planning, meaning anything where we don't have 5 years to do the planning, they say we're usually able to save about half of the assets. We can protect about half for the other spouse. Or it could be a single person, but typically we're doing this for married couples. So it's going to be a lot harder if that law ever passes. I'm going to start saying if now. I used to say when. I'm going to say if that law ever passes, it'll be harder. It will require you to plan ahead and do some planning if you really want to preserve as much of your wealth as you can. So the last point that we are trying to keep in mind when we're doing Medi-Cal planning usually is estate recovery. And you may be familiar with this concept colloquially. If you receive Medi-Cal to help you pay for nursing home care while you're alive and then you die, Medi-Cal is going to send a bill to your family. And it's going to say, this is what we spent on your deceased loved one, and now you have to pay us back. And that's the law. We have to pay back whatever we got from Medi-Cal. However, we pay back only from what we would call, in my world, our probate estate, meaning the assets that are passing from us as a dead person to somebody else. So what's in our probate estate? If we have a living trust, if we went to an attorney and we did estate planning while we were alive, we set up a living trust, and we moved all our assets into that living trust, we don't have a probate estate. That's pretty cool. That's a new thing that the legislature gave us in 2017. All you have to do is do some estate planning and you will avoid estate recovery. The other things that aren't in our probate estate are our IRAs, our 401ks, because we wrote down on a piece of paper, when I die, I want this person to get my IRA. So my IRA doesn't have to go through probate. Same with life insurance. Typically, we have designated a beneficiary of our life insurance policies. So that's not going through probate either. So estate recovery is very easy to avoid nowadays. There's really no excuse for anybody to have estate recovery. There are also exceptions to estate recovery if you have a surviving spouse or you have a child who's blind or disabled. You won't have estate recovery against you. But really, people shouldn't have to worry about estate recovery. All they have to do is do an estate plan. It's really pretty simple. We've been talking about the rules. Now I want to talk about what do we do with those rules? How is it that we do the planning? We just have to remember the basics that we've talked about today. We have exempt assets and non-exempt assets. So if we could take a non-exempt asset and turn it into an exempt asset, that would be great. So an example of a non-exempt asset is money in the bank. Money in the bank is non-exempt if it's more than $2,000. An example of an exempt asset is our home, right? Everybody can have a home and still be eligible for Medi-Cal. Well, what if your home has a mortgage on it? You have a mortgage on your exempt home and you have a bunch of cash in the bank. Maybe if we took the cash in the bank and paid off the mortgage, wouldn't that be great? Now we've turned a non-exempt asset into an exempt asset. Another way that we do the planning is by gifting. That's what I talked about when I said we have to disclose gifts. We make gifts to our children. We make gifts to our grandchildren. The basic idea is we have to get this money out of our own control if we're trying to be eligible. We can make the gifts outright. We can make them into a trust. We like trusts. In my practice, we use them a lot because it allows us to control the money. We've made a gift into a trust, and we can make sure by putting it in a trust that it is not going to be spent on something we don't want it spent on. It's not going to be exposed to the creditors of the trust beneficiaries, who are usually our children. When you give money to a child, if that child gets into creditor trouble, the creditor can take that money that you gave to your child because it's not yours anymore, it's your child's. So we generally like to use trusts rather than gifting to our children outright. It's a much safer way to go. Another strategy is to convert assets into income. If our problem is that we have too much asset, we can purchase an annuity. And an annuity, if it's the right kind of annuity, will be treated not like an asset, but like an income stream. The income that we're taking out every month from the annuity is not counted as an asset, it will just be counted as income. In that way, it'll be treated like an IRA. So we can take non-exempt cash, buy an annuity, turn it into an unavailable and therefore exempt asset. Sometimes what we do in our planning is we'll have a spouse at home who doesn't have enough income, and we don't have a way to get that income to the spouse at home. Remember I told you the minimum monthly maintenance needs allowance, the $3,090 that the spouse at home is supposed to be able to get. If the couple doesn't have the income to generate that, what are we going to do? The couple might have assets that can generate that, but the assets put them over the Medi-Cal threshold. So for example, the couple might own a rental property. The rental property is worth $300,000. They're not allowed to have that and still be eligible for Medi-Cal. But we can go to court and say, file a petition, Your Honor, we don't have enough income for this spouse at home if we get rid of this rental property. We need to be eligible for Medi-Cal, and we need the income from the rental property, so we need you, judge, to issue an order that says we are allowed to keep this rental property because it generates income for the spouse at home, and we can still be eligible for Medi-Cal. So that's a kind of planning that we sometimes have to do in order to make sure our spouse at home has enough income. And I've done a number of those. I've had a client with actually 3 rental properties, and he was able to keep all of them because he had not enough income without his rental properties. So those are just some examples of what we can do when we're doing the Medi-Cal planning. Thank you very much for coming tonight. I hope you learned a lot, and good luck with your Medi-Cal planning.